it has become the latest example of how American phone carriers have been reluctant to engage in data privacy disputes, especially those that may pit them against the U.S. government, despite their role as custodians of customer data, legal experts and privacy advocates say. Wireless industry trade group CTIA has shied away from the case, the most significant in years on phone privacy. Few private actors have been more involved in the erosion of Americans' privacy than the telecoms, particularly over the last 15 years, said Alex Abdo, a senior staff attorney at the Knight First Amendment Institute at Columbia University in New York, which filed a brief supporting expanded privacy rights in the case. They have been silent for almost all that time. Despite massive growth in the amount and types of customer data stored by phone and tech companies, U.S. law on how to treat that information has barely changed during that period. Some tech firms have urged reforms that would ensure privacy protections for customer data. Microsoft, MSFTO, and Google both opposed the government's attempts to obtain customer data stored on foreign servers, a central issue in the other major tech case currently before the Supreme Court. CTIA, AT&T, and T-Mobile declined to comment on the current case. Sprint spokeswoman Lisa Bellett said the company had not taken a position on it. Although the legal fight is about location information, the Supreme Court's decision is likely to impact how the government obtains other sensitive types of information from many other types of providers, Young added. Unreasonable search cell phone location records are becoming increasingly important in criminal investigations, with authorities routinely requesting and receiving this data from wireless providers. The four major wireless carriers handle thousands of requests from law enforcement annually for this data. Such data shows which local cell phone towers that phone users connected to when they made calls. Police can use past data to determine if a suspect was in the vicinity of a crime. Carpenters American Civil Liberties Union lawyers argued that police need probable cause, and therefore a warrant, in light of the U.S. Constitution's Fourth Amendment protections against unreasonable searches. Based on a provision of a 1986 law called the Stored Communications Act, the Justice Department said probable cause was not needed, but rather the lesser reasonable grounds, to show that records are relevant and material to an investigation. Civil liberties groups said that law did not anticipate the way mobile devices would become huge data depositories. Unlike internet firms, telephone providers require government licenses to operate, and many have signed contractual agreements that mandate cooperation with the government on legal processes, said Albert Guidry, a lawyer who represented phone and internet companies on surveillance issues for 20 years. Digital rights activists said this fact makes U.S. carriers reluctant to pick privacy fights with the government. On these issues, Guidry said, it does not serve them to be very vocal.